Lisbeth, we can open.
Lisbeth, do you want to unmute yourself and just do the opening for us?
Thank you. Yeah. Good morning, everyone. My name is Lisbeth Venter, General Manager from NAMA. And NAMA would like to thank Deborah and Naledi from the PPRA for being available today to host this webinar regarding the deregistration process for managing agents under the Property Practitioners Act 22 of 2019. Hopefully, after the webinar today, you will have a better idea of what is required and how to deregister as an estate agent. Please provide Deborah the opportunity to finish her presentation before asking questions. Questions will be taken after the presentation. And you are also welcome to post your questions in the Q&A section of this webinar during the presentation. The presentation and recording will be made available after the webinar, and therefore we go over to Deborah and to proceed with the presentation. Thank you.
Thank you, Lisbeth, and good morning, everybody. Welcome to the webinar. I'm very pleased to have so many joining us today and making some attempt to find out some of the more difficult aspects of the PPRA and the PPA itself. So I was asked to do a presentation on the deregistration process. There are a couple of things that I have included by way of introduction. And the reason I've done that is that very often managing agents and estate agents are two industries that you often have the same property practitioners operating in. So if you have someone registered as an estate agent, they often register as a managing agent as well, or as an auctioneer as well. So because of that, I've given the scenarios in the presentation for estate agents as well as non-estate agents. And in order to understand the deregistration process, it's important that you all understand the registration process. So we're just visiting that very briefly to start off with so that you can understand where the deregistration fits in and who has what duties when it comes to the deregistration of property practitioners, business property practitioners, and principals or directors. So without further ado, we'll move on. Please, if anybody has a problem hearing me, please will you indicate or somebody advise me. I'm not able to see hands, so I'm looking at the main screen, which is the presentation itself, but I'm very happy to have anybody stop me if there is a problem with audibility. All right, so if we move on to let me just move this to our next slide. For some reason it's not wanting to turn. There we go. All right, so as you're aware, all property practitioners operate in a regulated industry. That means that operation as a property practitioner is regulated and governed by certain legislation, which is compulsory, must be complied with, and nobody can opt out of that obligation in terms of the law. So anyone who performs property practitioner activities must register with the Property Practitioner Regulatory Authority as a property practitioner in the industry of choice. You can, of course, register in more than one industry, but in that instance, the same as in all industries, there has to be a business property practitioner with a principal or a director and employees or candidates or full status agents then register under that business property practitioner and principal director. So you need to register, you need to be issued with a valid FFC, and you need to renew your Fidelity Fund certificate every 3 years. Just to briefly explain for those who are not familiar with the Fidelity Fund certificate, your Fidelity Fund certificate is issued because, as a property practitioner, if you comply with certain obligations, any money, trust money that is lost or stolen, can be refunded to the owner by the Fidelity Fund, which is held and administered by the PPRA. So that's what's called a Fidelity Fund certificate. These requirements are established by legislation, which is the Estate Agents Affairs Act, up until 1976. So any legal aspects which arose before 2019, would have arisen under the old Act, and they would be dealt with according to the old Act. However, in September 2019, the new Property Practitioners Act was passed into law. It only came into operation on the 1st of February 2022. And so prior to that date, the Estate Agent Affairs Act remained in force. And on that date, it was taken over and replaced by the Property Practitioners Act. Now, as far as registration is concerned, you will be aware by now that there are two different scenarios, one for estate agents and one for non-estate agents, which is the other 11 industries which we regulate. So property practitioners who are estate agents register, first of all, a business property practitioner, a principal, a full status agent or non-principal, or as a candidate, depending on which one is applicable to you. Non-estate agents register as, firstly, a business property practitioner, which is your firm, a director, which is the responsible person of your business property practitioner or firm, if you're a non-estate agent, and you have the same role as a principal in the estate agents industry. And then everyone who is employed, who performs property practitioner activities, is required to register under that director as an employee of the firm. Let's look at your principal property practitioner first. Just to remind you of the requirements relating to a principal property practitioner. So in order to register as a principal, this person or property practitioner must register as the principal of a registered business property practitioner. You cannot register as a principal if you do not register a business property practitioner at the same time. That is a requirement in terms of the Act and regulations. So to be a principal, you must register a business property practitioner or firm. You must also be a director or member or trustee of that firm if the firm is a juristic person. You must have an NQF4, PDE4, NQF5, and PDE5 qualification, or alternatively have an equivalency exemption, plus your PDE5 if the Department of Education authorizes that exemption for you. And then your principal must ensure that he becomes CPD compliant and completes his CPD every year over a 3-year rolling scale. Your duties of a principal are that they are responsible for the compliance of the business property practitioner. In other words, the firm's audit reports, the firm's trust account records, all other compliance which the firm has to have, the display of its Fidelity Fund certificate, etc. All of those are the responsibility of your principal. He's also responsible for the employee's professional conduct, especially those who are candidates. And in terms of the law, he has a duty to oversee and ensure that his candidates are trained and behave themselves properly in terms of the code of conduct and the legislation. He is also responsible for the trust account and the trust money, and anything that happens to the trust account or the trust money, he will be liable for in respect of compliance. And then he is also responsible for the deregistration of himself and the business property practitioner when it ceases trading. We'll look into that shortly. Now, if we look at the non-estate agent industry, because your principal has to have completed certain educational standards, and there are no educational standards currently for non-estate agent industries, we cannot call him a principal, so we call him a director. And your director must register as a non-estate agent in a non-estate agent industry of his choice. He is the responsible person of the business property practitioner. He is also a director in the sense of being a director under the Companies Act, or a member or a trustee if the business property practitioner is a juristic person. He is not required to have any qualifications, and he is liable for CPD compliance. He is responsible for the compliance of his business property practitioner, that is the non-estate agent practitioner. He is responsible for the employee's professional conduct, the same as your principal is. He's also responsible for the trust account and trust monies, which are entrusted in that account or to him or his staff. And he is responsible for the deregistration of himself and the business property practitioner when they cease trading. So his duties are very much akin to those of a principal. Now we look at other property practitioners, and we have in the estate agent industry 3 types of practitioners: your principal, which we've already talked about, and then your candidate and your full status agent. Your full status agent is also sometimes called a non-principal. So your candidate is someone who doesn't have any qualifications and cannot register as a property practitioner as a result. So he registers as required by the regulations as a candidate property practitioner. The candidate registers under a principal. He must complete his candidacy within 12 months, which is his practical training. He has to complete his NQF 4 in real estate and his PDE 4 board exam. He then must upgrade himself to full status agent by applying to the regulator for an upgrade, and he must comply with the requirements for that upgrade. And then he must ensure that he is compliant with the legislation. He knows the legislation and he is compliant with it. And then finally, he must deregister himself when he ceases operating as a property practitioner. Your full status agent also registers or operates under a principal. He has to complete his CPD as required by the legislation. He must also remain legislatively compliant, and he also must deregister when he ceases operating. For non-estate agents, we've dealt with the director, and we then only have an employee. Your employee is any person who is employed by a non-estate agent property practitioner and performs property practitioner activities. Your property practitioner activities we've dealt with in previous webinars where I've gone through the definition in detail, and your property practitioner activities are what decide whether your employee must be registered with us or not. So your employee does not require qualifications at present. They are responsible to complete their CPD. They're responsible to ensure that they remain legislative compliant, and they then must ensure that they deregister when they cease to operate as a property practitioner. So we'll move on to deregistration. As I've said, estate agent candidates, full status agents, and non-estate agent employees deregister following a certain process. They submit a written request to be deregistered as a property practitioner. The Act gives them 14 days to advise us that they are no longer employed wherever they were employed and that they wish to be deregistered. And that 14 days, if they are leaving the industry, operates from the day when they cease to operate as a property practitioner. That is a requirement, and having done that, they are required to destroy their Fidelity Fund certificate if they have printed it. They may not use it for anything. And using a Fidelity Fund certificate which has lapsed is an offence. It amounts to fraud, and persons who do that can be prosecuted in a criminal court. I've indicated also that the FFC lapses by operation of law as soon as you are deregistered. So you don't have to actually go and ask for your FFC to be revoked or withdrawn. It happens by operation of law as soon as you are deregistered. So that also explains why an FFC that has lapsed cannot be revived. And if you come back into the industry, once you've been deregistered, you then re-register and go through the process of registration from the beginning. Deregistration by an employer, also a 14-day period for employment change. So where your employer has actually deregistered you, the effects are that because you are no longer working for that particular employer, you now cannot operate as a property practitioner and you cannot be registered as a property practitioner. As I've said, you have to register under a firm with a principal who is qualified to operate and oversee an employee or a candidate or a full status agent's operations. So as soon as your firm advises us that you are no longer working for them and asks us to remove you from their profile, we will then automatically deregister you as well. If, however, that is done, and within 14 days of your deregistration or your leaving of that firm, whichever happens first, you come to us and you ask for your employment to be changed to another entity, then we will reinstate you during that 14-day period, and we will then do an employment change and register you under the new firm without any cost. However, the Act and regulations give you 14 days to do that. And after the 14 days, you will have to pay the registration costs, the FFC costs, and comply with all the requirements to re-register. Okay? That's not the PPRA being difficult. It's not the PPRA deciding on its own requirements or processes. It is contained in the regulations, and we are obliged to enforce it. Okay, the consequences of failing to deregister for candidates, full status agents, and non-estate agent employees are, first of all, that in terms of the regulations, if you hold a Fidelity Fund certificate during any 1 year, you are obliged, before that FFC expires, to register or renew an FFC for the following year before the end of October. That doesn't mean your new FFC is going to be issued before the end of October. Your current FFC is valid until the end of December, but you will be issued with a new one for the new year. And you need to do that application or that renewal request before the end of October. The regulation goes on to say that if you don't do that and you have a current Fidelity Fund certificate, you have to advise us by the same date that you will no longer be operating as a property practitioner the following year. That has to be done in writing, has to be signed by you, and it has to be sent to our registrations department. When we receive that notification, we know that you are now no longer obliged to renew your Fidelity Fund certificate for the following year. We also know that you are not renewing it late. If you have failed to renew it by the end of October, you simply no longer have the duty to renew it. And so we will not then charge any kind of penalties or any kind of fines which the Act and regulations prescribe for you if you are late in renewing your FFC or if you operate without a valid Fidelity Fund certificate. Okay, so if you don't tell us by the end of October that you are not going to be operating the following year, and if you don't request to be deregistered, and you don't do that in writing by the end of October, you will be invoiced for a new FFC. And because you have not renewed your FFC by the end of October, various penalties will accrue. Those penalties will be payable when you do come back and you do re-register with us. Your compliance notice and a fine or disciplinary action may also follow, depending on what the circumstances are. So if, for example, we find out that you actually still are operating, then you will certainly get a compliance notice with a fine of 25,000 Rand. And if you don't pay it, you will be referred to a disciplinary committee to impose whatever fine or sanctionable conduct, what sanction they wish for the sanctionable conduct. If we are satisfied that you are not operating the following year, and that there was no duty on you to hold a Fidelity Fund certificate, you will nevertheless have penalties and fines accrue because of the fact that you failed to tell us in writing that you were no longer operating as a property practitioner in the following year, and the prescribed penalties in the regulations will then apply to you and will be payable when you return. We move on then to principals and directors of non-estate agents. Now, this is much more onerous and much more involved than simply a deregistration for an employee who simply is required to give us notice and to do that timeously and in writing. You must remember that your principal and your director of a non-estate agent firm are responsible for the firm, for the trust account, and for the firm's compliance. So as such, there's no such thing as a principal or a director of a non-estate agent firm simply resigning or simply selling their business as a going concern. In terms of our Act, if you resign as a director with SIP-C or a member with CIPC or whatever your position is, you remain liable as the principal or director of that firm until you follow the requirements of Section 54(9) to 14 of our Act, which is the section, or are the sections rather, that regulate what a principal and a director have to do when they're no longer operating as a property practitioner under the firm that they are registered under. So the first thing that your principal and your director of a non-estate agent firm have to do is to submit a signed request to us to deregister himself. That is the principal. You will know, as I've said, that a principal cannot be a principal if he doesn't have a firm. So if he's deregistering his firm, he will be deregistered too. So he requests deregistration for himself, and he also submits a signed request to deregister the business property practitioner. Along with that, he has to provide us with proof of the following. First of all, he has to wind up and pay out all trust money to the owner of the trust money that is in his trust account. He then has to close the trust account with the bank and submit a bank letter which confirms the date of closure of that trust account. The importance of that is that we now know what dates a winding up audit report for the trust account must cover. And for example, if you close your trust account and your business in August of 2026, Your 2026 audit report will have been submitted at the end of February, if your financial year end is the end of February, which it normally is. So in most instances, you will have submitted your audit report of your trust account, which covers the 1st of March 2025 up to the 29th of February 2026. Now you close your account in August of 2026. You now have March, April, May, June, July, and part of August that is unaudited. And so that is why you need to get your auditor to do a winding up audit report of your trust account, which will cover those months. And that must be submitted by your auditor through the auditor's portal. Along with that, your auditor's letter is required confirming that the business has in fact closed operations. You then also submit your bank confirmation of interest earned on the trust account for the current year, and you submit an affidavit confirming that you have in fact paid out all the trust money and that the firm has closed and been properly wound up. When we get all of that, we will check to see that your winding up report has been submitted, that there are no outstanding audit reports, that the trust account has been closed, and that you are compliant in all other respects. We will then deregister that firm. So this is quite a serious matter when we have a principal who simply abandons his firm in terms of our legislation, and none of this is done. Because when that principal decides one day to open another firm or to join another firm, we will not be able to assist him until he has resolved the previous firm and performed the audits and the deregistration process that is applicable. Your director of non-estate agent firms is required to follow exactly the same procedure. Okay, so failure to deregister your firm as a property practitioner. Your principal or director, as I've said, remains responsible and liable for any loss of trust money or any irregularities perpetrated on the trust account. So you are responsible for that trust account, and you will certainly be the subject of any inquiry or investigation in relation to any missing trust money, why the trust account wasn't closed, why the right to transact on the trust account was given to somebody else. And let me say, there's nothing to stop you letting somebody else transact on your trust account if that's what you want to do. But it's a very risky process, and most principals are aware that they should rather ensure that any transaction has to be authorized by them, whether it's by putting in an accept on their cell phone or whatever, so that they can at least control it. There was a firm that operated for many years in the Pretoria area, which was a very successful firm. The principal was well known and the principal of a number of different branches under this firm. He had a secretary who had been with him for 26 years, and she conducted all his trust account work, his trust account business. So she did deposits, did removals, did withdrawals, did everything, and he trusted her implicitly. He trusted her even with his personal business accounts and his personal accounts, bank accounts. He came in one day to advise us that he had just discovered that this lady had stolen 3 million rand from the trust account, and he was therefore unable to pay back deposits, and he wanted to advise us, and he also wanted to be able to continue working. Sorry, excuse me, this is just the CEO. I just want to advise her that I'm doing a webinar. Morning, CEO, I'm just doing a webinar. Can I phone you back? Thank you. Sorry about that. So yes, so he then wanted to be able to continue to operate so that he could get the money, earn the money back to be able to pay off the money that he owed his clients. Well, that was very laudable, but in terms of the act, first of all, he hadn't been able to submit an audit report because none of his auditor would not sign off his audit report on his trust account. And under no circumstances in that situation were we able to issue him with a new Fidelity Fund certificate because the Act doesn't allow it. So this is the kind of situation that you can find yourself in if you do not safeguard your trust account. We also need to be aware that principals and directors are responsible and liable on the basis of vicarious liability for the actions of their employees if they continue to work. So your principal and your director have to have oversight over them and ensure that they are compliant. And if you stop operating and you don't close down your business and you don't deregister the firm and you have employees who you entrust to somebody else to run the firm, you end up with the kind of problems which involve disciplinary action and very likely civil liability as well. And I've indicated that in item number 3. We'll move on to item number 4, which is that you remain liable to pay for your new FFC for the following year after you have after your current FFC has expired, and your payment of penalties for late renewal or non-renewal or failing to deregister are also accrue and will have to be paid. And the failure to do any of these things might result in a compliance notice, a fine or disciplinary action. So we need to be aware that for all property practitioners, not only do we have the kinds of problems that I have spoken about, but we have general consequences which apply to everybody. And the first is that when you do want to come back or you do want to register under another firm, there will be a delay in processing your application. The Act allows us 30 working days to issue a Fidelity Fund certificate from the date that we receive a compliant application. So this means that those we have a time limit, obviously. But that time limit only accrues when we have a compliant application, and you are at that stage entitled to register with us and receive a Fidelity Fund certificate. However, if you submit an application and you have a firm that is open, that has not been finalized, that's not been deregistered, or you have failed to deregister and you've got outstanding FFC payments or fees or penalties, all of that has to be resolved before your application becomes compliant. So instead of it taking 30 working days to get your FFC, it may take a lot longer. And then, of course, it will generally be our fault. And you will understand how, in that instance, the regulator is not responsible for the fact that there is a delay in you getting your Fidelity Fund certificate. Just on the question of Fidelity Fund certificate applications, where your application is not compliant, we have a number of cases that happen every day where we get emails from people, emails from companies saying, I've been waiting for 137 days for my FFC and I still haven't got it. Okay? And the impression is created that we have failed to give you an FFC for 6 months. In fact, when we look back at that, we find that your first application for an FFC was submitted 137 days ago. It was non-compliant. It was not accompanied by half of the requirements that it needed. We responded to you within a month to advise that your application was rejected because of the fact that the following was outstanding and inviting you to please resubmit your application. You then submitted to us a further document, a single document, on the 18th of December. And on that date, we got a document. We didn't get a full application as we asked you to send. We didn't get any of the other documents which were needed for us to be able to process it. And so we went back to you a month later and we said, please, your application was rejected. You were told that. Please give us a new application form and include the documents that were not in your previous application. And these are the documents. And finally, exactly 11 days prior to receiving this email, we received a fully compliant Fidelity Fund certificate. But in the email, we are told that they've been waiting 137 days for their Fidelity Fund certificate, when in fact they've been waiting 11 days. So please be aware of the processes. And we have said this on our website many times. The notices are there. I have advised in webinars exactly how the process works. And if we just ensure that your application is fully compliant, and if it's not, that you send it again with the additional documents or the additional requirements that you were told were not there, then we will have no issues with the delays of not being able to issue you with a Fidelity Fund certificate. So, first of all, you're going to have delays. Secondly, you're going to have fines and penalties to be paid before you can register. Principals and directors will be required to wind up and deregister any open firm, whether they were operating or not. And please remember, principals and directors, that the Act doesn't say that if you have a trust account but it's dormant, or your property is not your property practitioner business is not operating, that now you don't have to perform the audit requirements. Okay, it's very clear that once you have an open trust account, it must be audited, whether there are transactions or whether there aren't. Okay, because we cannot accept anybody's word for the fact that there's no transactions that went through that. We need to have an audited report confirming that, because that will in fact put us in a position to do our oversight as we are required to do in terms of the Act. And no Fidelity Fund certificates may be issued under the legislation for any firm or to any person, even if they have a different firm, or even if they're employed by a different firm, if the firm that they previously were principal of or director of is not compliant. And you need to remember that your non-principals, non-directors, which is your employees, and your candidates and full status agents can only be registered under one firm. Okay. So finally, just a heads up on a few things. Principals and directors, be aware that the dangers of not conducting oversight of employee property practitioners are serious. First of all, it is a duty that is imposed by the law, and you may incur vicarious liability. You may incur disciplinary liability if you fail to perform that oversight function. The same in relation to your trust account and the oversight that you have to enforce in relation to your trust account. Directors and principals also have a duty to train their candidates and their staff. You will know of the FIC requirements. You will know how training, and many property practitioners have got beautiful FIC requirements, all nicely written out and published and bound and what have you for people to follow. But the FIC legislation requires that you actually train your staff to be able to understand and to implement that. And so many people fall down on that when there are inspections that are conducted either by FIC or by the PPRA. And the dangers of not remaining in control of the trust account are personal civil liability, disqualification, and the possibility of high court legal costs. And the reason I say that is because we have regularly principals who come to us, and this doesn't apply to the same extent to directors, because there's no reason for a non-estate agent entity to require a stand-in principal. Like everybody can register their own without qualifications. But with the estate agent industry, there are many people who have their own companies that they want to start operating under as a property practitioner, but they are not principals and they are not qualified. So what they do is they find a principal who is prepared to act as principal of their firm and register with us as principal. and they will have an understanding with that principal as to what his duties are. They will make that principal a director of the company, which they're obliged to do. And then they will have an agreement that after 2 years or after a year or whatever it is, he will step down, and the new principal, who is now qualified, will take over and step in as principal, which is absolutely fine. As long as that principal, who is the stand-in principal, takes control of the business, takes control of the employees, remains in control of the trust account, and operates that business as his own, because he is liable for that. In those instances, very often your company directors will have some agreement with the principal to say, we will pay you an amount monthly for your services. Alternatively, we'll give you a percentage of the commission earned during the time that you're acting as principal, etc. And the problem arises in that many principals in this position accept the company director's advices that they will run the company, they will do everything that's required, they will submit the audit reports. The principal doesn't need to do anything. We simply need his name and signature, and he doesn't have to worry about anything else, and we'll pay him his money every month. Okay, that's all very well until such time as the audit report submission time arises and they fail to submit their audit reports. We are going to go to the principal and we are going to hold the principal liable. The principal, who may have his own company, and his own company may be fully compliant, is now prevented from obtaining a Fidelity Fund certificate for his own company because this other company, which is also his company in law, because of his registration as a principal, is not compliant. And we have those principals come to us, I can't find the people, they've disappeared, they've run away, they don't answer my phone, I don't know where to find them. I've tried to go to the bank and get the bank to give us, to give me this bank statement so I can have an audit done. And the bank says, no, you're not a signatory on this account, so go away, we can't help you. And they come to us and say, please, can you deregister me from this firm? And we say, absolutely not. You have to wind up this firm, you have to close down the trust account, you have to do everything that's required, and you have to submit your outstanding and winding up audit reports. And your principal says, well, but I can't do any of that. And we say, well, you mean you're not in control of the trust account? You mean you're not in control of the firm? This is a matter which needs to be referred to enforcement. And those principals sometimes end up having to go to the High Court for an order allowing them to go to the bank and instruct the bank to provide them with the necessary documentation to close the account and to be able to operate as if they were the owner of that firm. And it is an extremely expensive and extremely onerous and very unpleasant process. So please, principals, do not put yourself in that position. Remember that you have to wind up and close down that firm that you are responsible for when you are the principal. I'll just touch finally on one other aspect, and that is that if you as principal are in fact the principal of the firm and you wish to leave the firm and somebody else wants to take over the firm as a going concern, maybe you've sold the firm to somebody, maybe you are retiring and somebody else in the firm who is a principal and qualifies will take over the firm from you, or your son will take over. Whatever the situation is, you can then apply to us to be removed as principal, and your new principal will then apply to be substituted for you as the principal of that firm. But we will only release you once the new qualified principal has been joined as the principal in that firm. And then we will release you. And that firm will continue to operate with a new principal. So I hope that that makes sense to you. Thank you very much for your attention. If there are any questions, I'm happy to answer. Thank you.
Thank you, Advocate. We're going to go to the questions now. Thank you for presentation. Let me see what we have. We also have the hands. I'm going to give a chance and unmute everyone so that you can ask your questions. Okay. Our network here is still picking up. Okay, advocate, I have a question from Izil, and she says, can a principal director be registered under more than one firm?
Yes. Yes, a
Thank you.
principal can be registered under more than one firm. He can be registered under as many firms as he wishes. A director in your non-estate agent entities can also be registered under as many firms as they wish.
Okay, thank you so much. I have another question. Let me go to this one. Where do I send a written request to be deregistered? Email address, please. And I think you did mention it, advocate, in your presentation.
It's
Maybe they saw that.
registrations, registrations at thepra.org.za.
Okay, there's the email address. I'll also put it on the chat so that you can see it, so they can help you.
Thank you.
Lalitha says, if you deregister as a principal or full status agent and you decide to come back into the industry, can you re-register under the same status you left the industry so that you don't require NQF or PDE?
Okay. The answer to that one depends on the circumstances. All right. So if you were a principal before and you were deregistered, if you want to come back, you have to have obtained the qualifications that are necessary for a principal. So if you have got NQF4, NQF5, PDE4, and PDE5, and you had that before you left, you can come back and you will be registered as a principal. If you don't, if you had an old qualification prior to 2008, you will know that the 2008 regulations made it compulsory for everybody to obtain those qualifications within a period of 2 years. That 2 years has been extended a number of times, and the only people that were excluded from having to get those qualifications as principals were those who had been principals and held principal fidelity fund certificates for 5 years prior to 2008. And if you did that and you could prove that, then you could be exempted from the NQF4 and NQF5 requirements. Okay, so in those instances, you would be able to come back as a principal if you were exempted by the education department. If, however, you didn't have those qualifications, you would have to come back either as a full status agent if you have your NQF4 and PDE4, or as a candidate if you don't have any of those qualifications. Okay.
Thank you, advocate. I have one from Kim. I understand that there is currently a backlog with the deregistrations. Please confirm what is required. Do we still submit the request to deregister before end of December 2025 in order, and I think she's trying to say in order so that we can be recognized? We are remaining registered as a managing agent, but deregistering as an estate agent.
There is no backlog in deregistration. Okay, so if you have not been assisted, then you need to please provide your information to Naledi so that I can follow it up. Please note that if we are delaying in deregistering you, all you need is to provide us with proof that you submitted a written request to deregister before the 31st of October of that year, and we will not charge you any penalties. We will not charge you anything else. Can we have someone just mute, please, so that I can continue?
It's Elise. I just muted them. I'm checking others. I think there's someone else. Gobisa, let me mute them.
Okay, thank you.
Sorry.
Okay, so right, we were talking about deregistration, and the fact that you have applied and you haven't been deregistered. So if you have that document, please send it to Naledi. We will not charge you any penalties or any fees if that request to deregister has fallen through the cracks and we have for some reason or other not actioned it. But there's no backlog with deregistration. If you want to deregister under one firm or you want to deregister that firm and you want to re-register the same firm under another entity, another industry, that's fine. You can do that. That will obviously take a little bit longer. But a simple deregistration to say, please remove me from that firm, that will happen within a couple of days. So if there's a problem, please send that to your details plus a copy of your request to be deregistered to us via Naledi, and we will ensure that it's done speedily.
Thank you, Advocate. Steven says, good day. I have renewed my FFC for property practitioner. My PPRA shows the renewal, but the FFC cannot be downloaded. How do I get my FFC? I think, Advocate, it's speaking to that communication you issued on the social media and the CEO's video, Advocate.
Yes, thank you. We are, as you know, most of them have been, but we are at the moment undergoing development, and we've said this a couple of times. We've got IT development happening. We are going to be doing all sorts of new things, which will, in the new year, as soon as the development is finished, which will be much easier for everybody. And certainly we hope that it will be a lot speedier. So at the moment, because of the development, there are certain FFCs that we have generated on the system, but the system cannot transfer them to the portal. So it's difficult to download them. So if you can't, please will you send an email to ffcrenewals@theppra.org.za or to Vukani Mbata, VUKANI.MBATHA@theppra.org.za and ask for a copy to be printed for you and sent to you, and we'll be able to download it from the system and send it to you.
Thank you, Advocate. Elsa says, good morning, PPRA. Where do we as a business remove a practitioner that has left our employment? Thank you.
You don't remove them, we remove them. So you send us an email saying, please, in writing, obviously, and you say, please, this person is no longer employed with me. They are leaving or they have left on this date. Please remove them from our profile, and we will attend to that.
Okay, thank you so much for the hands. I'm going to come shortly to the hands. Bear with us. Lara on the chat says, if you are closing the business but moving to another agency, why would the principal deregister?
Sorry, I don't understand the question. If you are what? If you are
closing a business, maybe she wants to close her company to move to, so changing an agency.
Yes.
Maybe from one company to another. She's asking that she need to deregister the other company to open another company.
Okay, so I'm still not very clear. But the first company, which she's closing, she has to deregister that company, right? If she's the principal.
Yes, and wind up.
So if she's not operating that company anymore, then you deregister that firm, you do the winding up, you close your trust account, you do everything else you have to do, you deregister it, and then you apply to be registered under another firm as a full status agent or a non-principal.
Okay, thanks. Kim, I see your question. We are deregistering as an estate agent and not managing agent, so we are keeping our trust account. Please confirm what is it that we need. You see the email address that I've pinned for registrations. I'll ask Lerato to send you the requirements for that. If you can send us an email. Let me go to Lillian.
I can just add something, Naledi, before you do that. In that instance, you don't need to close and wind up your trust account as far as the entire closure of the trust account is concerned, but you do need to do a winding up report through your auditor for the estate agent section. So he will wind up the estate agent portion of that business and he will submit it to audit. You will also get a letter from the bank saying that the trust account is still open and that it is still being operated, and you will get your affidavit where you will say that we are no longer operating, we've closed our business, etc. We've paid out all our trust money to anybody who operated under our estate agent business, and we now are going to ask you to please deregister the estate agent business and keep the managing agent business open. And all of that deregistration of your estate agent comes to us, and we will then also send it to audit for them to do an annotation to close the trust account on our books under the estate agency.
Okay, no, thank you for that. Lillian says it's a long question, but if Lillian, I don't capture it properly, please raise your hands. Let's engage. She says, Advocate, I've been employed as a property practitioner since 2022 with a company. I was given a certificate, and recently I looked on the FFC history, and I do not understand how it is possible for FFC withdrawn, manual, not stated on my history for 2024. How can this be possible? Okay, I'm quite not getting it, because she says, how can this be possible happen? I think because there's a lot of spelling errors. I'm struggling to capture it, but
Naledi, I might have an idea. You may see a withdrawn FFC on your profile or your history, where, for example, you have your Fidelity Fund certificate, you register as a candidate, you then perform all your property practitioner education requirements, and you then ask to be upgraded to a full status agent. Now, in that instance, our system used to issue you automatically with a new FFC. Now, that is not allowed under the new Act. So what we have to do in that instance, while we are changing the system, is to withdraw that new FFC from you. Your current FFC continues to be operative until such time as you renew it, or you apply and ask for a new Fidelity Fund certificate and pay for one. So that may be, if there's a withdrawal, it may have been one that was issued as a result of an upgrade. I'm not sure if that's the case, but I can't imagine any other reason, unless there was some disciplinary action of some sort where the FFC was withdrawn by an adjudicator, or alternatively, where there was a system glitch and the system issued a duplicate FFC and we had to withdraw it. So that's the only circumstances under which that would happen.
Thank you, Advocate. Paul says, I have submitted documents via email to be registered on the new employment firm with a new FFC, but I have not received any feedback. Please advise. I think this is a follow-up. You have to send us your 7-digit reference number on the registrations email. We'll check that application for you, the status of it, because we have to see if the documents are compliant, and we will give you feedback on that one. Let me go to the hands. Okay.
Naledi, if you want to, they can send that to you or to Lerato, and Lerato can check it up for you.
Yes, true. Can we have the recording of the webinar? Yes, we're going to put it on PPRA TV tomorrow at 11 a.m. Our communications department will upload it for you. Then you can access it there. You'll also find previous webinars that we've put there on the YouTube. To answer as well, Crystal, same question. Let me go to the hands. I'll come back to the chat so that we give others a chance. Vanessa, you're the first hand. You can unmute and ask your question. Thank you. Vanessa? Okay, I'll come back to Vanessa. Christine?
Good morning. Good morning, Naledi. Good morning, Advocate.
Morning.
I have actually 3 questions, if you would bear with me. I am a principal. I used to be a principal. I had my own firm. As I am entitled, or as principal, I could have more than one FFC. I joined also with EXP South Africa, and I applied for my full status agent FFC under EXP. That was end of 2022. There I was issued with a principal FFC. Percival, I can't remember his surname, actually visited me at home, and he informed me I am entitled to 1 principal FFC and I'm entitled to 5 FFCs, of which 1 is a principal.
Who was this person? Sorry, can you tell me?
Sorry?
Can you tell me who this person was who visited you at
Percival
your
is his name. I do not know his surname. That was about 1 or 2 years ago.
You said his name was Percival?
Yes, from the PPRA. He was to come and do an inspection on my, yeah, and I was not the principal of EXP, although I was issued with a FFC as principal. That is the one issue. The second issue is I had my rental book in my own company, for which I have my original principal FFC. We sold the shares of the company earlier this year, and we received notice that we were deregistered. I want to deregister my principalship. The notice that we received is we would like to confirm the removal was processed on the 18th of July 2025. That's now the removal of Christine Appel as principal. That is now under Emerald Realty. Please note that the agent is no longer associated with the firm, which is fine. That is how it should be. But is that a confirmation that my status of principal has ceased? That is my one question, because that's what we applied for.
Okay, I'm finding it a little difficult to follow what you're saying, but from what I can explain the following. You must remember your FFC since 2022. Your FFC no longer has your status on it, and you are no longer registered in terms of that FFC, where it is actually linked to a specific status. So your FFC shouldn't show you a status at all if it was issued after 2022 or during 2022.
And on our profiles on the PPRA website?
Now, the profiles on the PPRA website are a different story. And you need to remember that if you are a principal, that is your status. Your status doesn't change because you are going to work for a company as a non-principal.
Okay.
Okay.
Thank you. You've answered me.
Because the non-principal status is actually your role at firm. Your status as principal remains the same.
Now, the fact that I received the email of the 18th of July this year that say that I am that I was removed from the firm, and that I'm no longer associated with the firm. Does that mean my status have changed? In other words,
no, your status should not have changed if you had another firm that you were principal of.
No, but that is the point. That brings me to the point, is that according to the PPRA, I'm seen as principal of both the company which I sold, plus EXP South Africa, where I'm currently as a full status agent.
No, I don't think that's the case. You may be seen as the principal because that's your role at the firm in the other one, or that's your status. But if your role at the firm is non-principal, then you will not be seen by us as the principal.
Okay, so the fact that I am deregistered, that means that I am no longer a principal.
Which firm is deregistered, or are you deregistered from both of them now? Is that
no? I am still a full status agent, and I have my FFC, and I have my renewed FFC for 2026 going forward. For EXP as a full status agent, I have that FFC.
Right. And your previous one, you sold that, and did you deregister the firm?
Yes, we did. It was quite a process.
Yes.
And we received a notice from the PPRA to confirm that I was removed on the 18th of July 2025.
Right. So that means that firm
no
was
longer
then deregistered?
with the firm. No, that is my question. I'm no longer associated with the firm, but I am scared that my principalship has not been cancelled, which we applied for to be cancelled.
No. You must remember, it has to be cancelled. And that's because, as I said to you, you cannot be a principal if you don't have your own firm.
Okay.
So if you are a non-principal under EXP, but let's check that for you. If you want to, please send an email, and I think the best person to deal with this is Lerato. So please send it to Lerato, L-E-R.
L-E-R.
A-T-O.
I'll type it on the chat, Advocate. I'll type it on the chat.
You.
Okay,
all right. Lerato Malotsi, she'll be able to check that your status is correct under the other one, and that you have in fact been deregistered. But just give her your PIN numbers for both the firms, please, so that she can check them.
I will do. And then my last question, my sister and previous co-director with our company, which we sold, she retires now, and she has submitted everything that you required 3 times already for deregistering as an agent. She wanted to deregister, not functioning anymore, don't want a new FFC, and still she get an email from the PPRA to tell she must submit the documents.
Okay, but now did she submit your CRPC documents which show that she's no longer a director?
Yes, absolutely. And she
Everything.
I mean, she doesn't want to have an FFC anymore. She's finished
Yes.
and klaar with, she's retired,
Yes.
she's 70 years old.
Yes, but you must remember that if she is still a director on the CRPC documents.
No, she is not.
I know that, but what I'm saying is, if
Mhm.
she was, then we could not deregister her. Okay, because all directors in terms of the Act have to have a Fidelity Fund certificate. So
Yes.
there seems to be some reason why they have not, they haven't got the SIPC document that they want, or there's something that they've not been satisfied with. So I need to follow up on that as well to see what the issue is there. But perhaps if you can also
like a miscommunication. It seems like a miscommunication. She's very meticulous with her work.
Yes.
And she makes sure that she knows what to submit, and she has submitted everything.
Okay.
On request,
All right.
I submitted it the second time, and then when she followed up on that, it got back to her and said, you must submit the documents, but it has already been there 3 times.
Yeah. Okay.
Everything.
No, well, it may, I'm not sure if they're different. She sent it all to the same email address.
That I can't answer.
Okay. All right. Well, it's possible that it's gone to the incorrect department or something. But I think if you can just send to send her documents to Naledi with her PIN number and say that this is the one where she submitted 3 times and she's not getting any response, and Naledi will refer it to us, and I will expedite it. What is her name?
Cecile Victor.
Victor. Okay.
Yeah.
Fine. Thank you.
And I'm Christine Appel. Thank you so much. I do appreciate it.
Okay.
Thank you.
Thanks.
Okay, and maybe to add, advocate, I think if you are closer around Sandton or Johannesburg, sometimes it's better come to our offices, walk in, and your issue can be resolved on the same day. It's easier like that when you are sitting with a consultant. They go through your applications one by one to tell you what is required. It helps. Maybe before I go back to the hands, I have a comment from thank you, Advocate Weil, for a very informative session. Let me go back to the hands. I'll come back to the chats. Christine, we've helped you. Elise? Please unmute.
Hello.
Hi.
Yes.
Hello. Good morning, Advocate Val. I'm Teresa. I'm the principal of Midnet Properties. Just to come back to your discussion earlier of the NQF5s. I opened my agency in 2001 as a principal, and then 2008, when the new legislation or the requirements came into play, I actually did my NQF5 straight away. At the time, we were advised that we don't have to do the NQF4 prior to the NQF5 because I've been in the industry for many years and a principal of my own firm already more than 5 years. Since then, I've got the PDE exemption and I've got the full status of the NQF5, but I am in the process for the next year or two to be selling my agency to one of my colleagues. I might decide to actually stay on as an agent, or maybe deregister completely, and maybe in 5 years' time, I might decide to again join just as an agent. I have no wish to again embark on the NQF5 route or a principal route. But now on my PPRA, the education grid, it is shown that I don't have an NQF4. Although I've done my NQF5 and I've got the exemption, what do I do to rectify it? I wish not to do the NQF4 at the moment because I feel I'm way beyond that level. Will I be able to come back as just an agent and and practice as an agent, whilst I don't have the, according to your grid, I don't have the NQF4, but I do have the NQF5.
Okay, that's a question which the education executive would need to answer for you. I'm not, unfortunately, in her department. I'm not sure on what basis they granted exemptions and on what basis they didn't. And I know that there are some CETA requirements which they have to, which people have to comply with in order to get their various designations. So, Naledi, can you put Zandile's email address into the chat? And I would ask you to just contact her. She's the executive of the education department, and she would be in a position to explain what you can do to resolve that issue.
Okay, thank you so much. Just one more question. On our FFC history or on our grid, it shows that Midnet doesn't have a principal. One of my agents couldn't, well, she got a FFC, but on the status, it states there, no principal or something like in that order.
No principal FFC issued.
Yeah, mine was issued actually. I'm sitting with it, and I am the principal. But it's on her screenshot or whatever. It shows that the description is there that no principal exists or something in that order.
Okay, I think probably that is an old message, because if her FFC issued and yours issued, then that situation would have changed. Otherwise, it wouldn't have issued. So what sometimes happens, and this is because of the new act and the fact that we are trying to get our systems to be able to accommodate it. So if I can just briefly explain to you what the problem is. Under the old act, you are aware that every principal needed an FFC under every firm that he operated or she operated. Now, under the new act, there is a provision in the regulations which says that if you are a principal, you only have to have one FFC, which is good enough for all the firms that you operate under. Okay, so the clever individual who did that didn't bother to find out what that would mean on the ground for all of us. And because our entire IT system is based on the fact that everybody has their own FFC and every firm has their own FFC and every agent has an FFC under the firm that they are registered under, that simply could not be implemented. And so there's been a huge amount of development necessary to be able to accommodate that requirement. And what it's meant is that we have to create, or the developer has to create, what we call a floating FFC. And your floating FFC is now an FFC which can be issued to an individual principal, and it's actually recognized by the system as an FFC under all the firms that he has. At the moment, however, because that is still being developed, the system is looking for the principal's FFC issued under every firm. It's not taking notice of the fact that the principal's FFC under Joso Properties is still valid, even if it's not under EXP. All right. So the results of it is that it gives you that kind of message. It says, no, we can't issue the employees FFCs because the principal doesn't have one. And it doesn't recognize the fact that the principal doesn't need one because he's got one under another firm that is still valid. And the difficulty with that is that we've had to get our system developed to be able to issue those FFCs, and there are still a large number of them that the system is not issuing. So our developer is working very hard to issue them. So you and her are fortunate. Apparently you've got your FFCs, and the system has now seen that you have one, and so they've issued hers as well. So that, okay, I think is the position there.
Okay, thank you. But she cannot get access to her CPDs and things like that. So she's actually excluded.
Yeah, CPD, I don't know why. CPD is an education department issue, yes. and they need to find out what the issue is with her CPD. Unfortunately, I don't work with it, so I cannot help you. But if you send an email to that same lady, Zandile, she will be able to put you in touch with someone in CPD in her department who can assist you.
Yeah, the email is on the chat. Let me go to the chat again. Andra says, to clarify, does a managing agent still have to register at the PPRA?
As a managing agent?
Managing agent.
Yes, absolutely.
Let me go back to the hand. Gracias. Please unmute.
Yes, thank you so much, Advocate, for
Yes.
such good presentation.
Thank you.
Actually, my issue is this one. I'm registered as a principal under my own company. And then there is a director who approached me to help because she was falling under that situation whereby being in the old legislation where they were just acknowledged as principal by the fact that they were member of the CC and all that. Then she left for quite a time and then came back. They could not recognize her by the education department until she does the NQF5.
Yes.
Then she approached me to see if I could just have to stand for them as a principal,
Yes.
which I accepted. Then I got their company being registered under me. But
Right.
along the way, it happened that she was no longer complying with the principle of having me supervise what is happening with the trust account, with all the banking and all that. So I told her, okay, because it is my responsibility to respond to PPRA about the running of the business, and you are not allowing, then I rather withdraw from your company. We agreed. Then we proceeded. We started with removing me from the CIPC certificate. Then, because I gave her two options, either I deregister the company completely, as I was told at the PPRA, or she gets someone else to replace me as a principal, which gives them the opportunity to continue running the business without me. We agreed on the second option, whereby I can get replaced.
Yes.
So now we drafted the resolution. I presented my resignation letter. When it comes for her to co-sign the resolution, she doesn't want to sign anymore. So I'm stuck in a position where, okay, I don't want to cause harm because I know that there are people working at that company. I want to be removed just as a principal, get them continue with someone else, but I'm not allowed to do it because I don't have the resolution to submit. On the other hand, I don't have access to the banking because she's the sole signatory, whereby I can go for winding up and all that. So in this situation, what do you suggest I should do? Because
Well,
already with the CIPC, I'm no longer there.
Now, you see, that's exactly the situation I explained earlier that you need to avoid.
Yes.
Because when you're in
Yeah.
that situation, you put yourself in a position where your hands are tied and you have no way of closing down the company without going to the High Court and getting a High Court order to shut the bank account, etc. So you have to either work with them to get another principal who will take over, or you have to go to court and get the documents that you need, the order that you need to be able to close down the company and deregister it, because we will not remove you as principal unless another principal takes over or you close and deregister that company.
Thank you so much. So I understand that the only for me is to go to court.
Yeah, that's basically the only thing you have to do. Thank you.
Colleagues, because I'm looking at the time, we have to finish by 1. Can I ask that you keep your questions short, maybe like 60 seconds, so that advocate can try to answer everyone? Because I noted the Q&A, the chats, and we have a lot of hands. Let's go to Mel. Please unmute.
Hi, good afternoon, and thank you very much for taking my question. Mine is based on the advocate. You said that the property practitioner or a candidate property practitioner can only be issued an FFC or do the training within 1 year. And I think, if I'm right, it can be extended for another year. I'm under correction on that one. My question is, with principals that doesn't deregister property practitioners that don't do their qualification within the stipulated time period. Will the PPRA intervene? Because I feel that our industry is highly stocked in the bottom echelons with candidate property practitioners.
Yes, we certainly are. In terms of the regulations, we are currently issuing candidates with a 3-year FFC simply because our system isn't able to issue them with 1-year FFC. We are currently developing the system so that it can issue a 1-year FFC, and we're hoping from early next year that will be in place. But certainly in terms of the regulations, we have advised, and our education department has had webinars and seminars on this, that they have literally. In fact, the regulation gives them 6 months to do their candidacy, and says that the candidacy cannot be longer than 6 months. However, it says that the board can extend that, or the authority can extend that. We have extended it for another 6 months. So they have to do 12 months. And the reason for that is that the practical training component of the candidacy is contained in one of the NQ4 modules. And the NQ4 module takes a year. So we have a situation where CETA and QCTO have developed a qualification which we have to use, which doesn't speak to our Act. And as a result, we've had to extend it, the period, for 12 months. After 12 months, the only way that they can be allowed to continue further is if we make a further concession, to say that we will allow longer, or otherwise they apply to us for an exemption in terms of Section 4 from the time requirement, and that will not be granted easily. I can advise that I know, and as I say, I'm not an education person, I'm not in education, and that department has to speak for itself, but I am aware that there is a huge mix-up at the moment between CETA and QCTO and us in relation to their qualifications, and they are unable currently to provide exams for some of the qualifications. And on the basis of that, we may need to extend that further, and say that until CETA can provide the exams and allow people to sign off and then be upgraded, it might mean that they have to be a candidate for longer. But we're certainly very aware of that. And those people who have been in the industry for years and have remained a candidate past the period of time which was allowed previously and which is allowed currently will not be allowed to get an FFC at all as a candidate if they've gone beyond the required time period.
Thank you for that. Let's go to Marvin. Please unmute.
Hi, advocate. Sorry, just going back to where you have a principal who has multiple firms.
Yes.
We've got one where we've got 3 of his firms are due for renewal at the end of October, which we've obviously applied for, but he's got other firms where the FFCs are not due for renewal.
Right.
Am I understanding correctly that because of the other firms' FFCs not needing renewals, that we are actually compliant? Because he still has a valid FFC,
yes,
even though it's not under our company.
Yes, yes. He is compliant. His employees under this firm are not, if their FFCs haven't been issued, and they probably haven't because our system is battling to issue them.
Oddly enough, they were all issued last week, which was we were quite relieved. Most of them were, yeah.
Okay,
so
great.
My
then
question is, like, can I still get a firm FFC for our firm?
Yeah, if he doesn't have an FFC for your firm, but he has another one.
Yeah. What was the E1's problem?
Sorry about that. Let me mute. There's someone speaking. Colleagues, let's mute when others are asking questions. I've muted.
Okay, so yes, I'm pleased to hear that because we did an amendment to the system last week, and obviously it's been working. Those have been issued now, which I'm pleased about. But certainly your principal doesn't actually need an FFC under this firm because he has one that is issued and is valid and current under another firm, which in terms of the regulations is sufficient to apply to all firms.
Okay, so in order to get the firm FFC though, how do we get the firm's FFC? Because obviously that's what I'm looking for now.
Yeah, okay. No, that's no problem. The system should have issued the firm's FFC along with the employees' FFCs, but if it hasn't, please send us a message and ask. You can send it to FFC renewals at the ppra.org.za and ask for the firm FFC. Alternatively, if you want to send it to Naledi, she can also send it to the correct person.
All right, thank you. So, because there's actually 3 entities that I'm looking for his
Yes,
firm
that you need
FFC
big firms.
Yeah.
Right.
Yeah.
Okay.
Okay, thank you.
When you email me, just put your 7-digit reference number so they can find your profile quicker. Let me go to Cynthia. Please unmute. Cynthia. Okay, let me go to Elise. Elise.
It's Teresa again. Just two very quick questions, and maybe it's stupid questions. Can one firm have 2 principals?
Yes. One firm can have as many principals as they want to, as long as the principals are qualified as principals, and as long as they are all either a director or on the CRPC documents, or a member on your member documents, on your CC documents, or alternatively a trustee on your trust deed, if it's the trust that holds the firm. So your principal has to be, remember, your principal has to be a director of the firm if it's a company, or a member if it's a CC, or a trustee if it's a trust. So as long as he's one of those, if you have a sole proprietorship, you can only have one principal. You can't have more. If you have a partnership, you can have as many principals as there are partners.
Thank you. And then just even a similar question, maybe I've missed it. On the new legislation, must a firm also have an FFC?
Yes.
Okay.
Firm has to have an FFC, has to be issued to it, and it has to display it at the place of business.
Thank you.
Thank you. Percival, please unmute. Percival?
Good day, Naledi.
Yes, we can hear you.
Yes. Good day, Advocate. Good day, Naledi. Yes, my name is Percival, not the one that was mentioned earlier on. My name is Percival Havana Khosi. Just a quick one. That seems to be a bone of contention. One, I'm also a principal of my own firm, and I also stand in as a principal of another company. But of course, I was not happy because the issue of commuting between Kimberley and Johannesburg most of the time. As a result, I've resigned. Now, I am aware that, yes, there is a risk involved in acting into multiple companies as a principal. What I did in addition to that, I made it also conditional to say that I can act as a principal on condition that you involve a third-party processing payment processing company, which in this case was referring to PayPro. I did that. Now, one of the requirements, I'm in the process of trying I've resigned already. I'm in the process of trying to deregister, but there's a bit of a problem in terms of the person that I'm dealing with. She's sending me from Peter to post. One other requirement was to say you must wind up the firm's account or whatever. Tell me the role that is played by the payment processing agent. Does it really also assist in terms of mitigating risk in this situation? Was it going to be the only thing that is going to be required for me in terms of winding up and the letter of deregistration of the company? What becomes the role of the payment processing company involved in this case? Thank you.
Okay, the payment processing company has no liability whatsoever in relation to any of its clients to deregister or to wind up or to do any of the requirements in relation to the deregistration of a company. What the payment processing agent does is it receives the trust money, it holds it in a trust account on behalf of the property practitioner, and it provides us with the audited statements, the interest earned statements, etc., which have to be submitted to us on a regular basis as required while the firm is operating. And that is basically the sum total of your payment processing agent's job. So if the principals want to deregister the firm, they will then advise PayProp to close the trust account, and they would get a letter from PayProp confirming that the trust account was closed and the date of closure, and they would use that to deregister the firm.
Okay. No, thank you so much, Advocate.
Okay.
Thank you. Let's go to June. June.
Hello. I'm representing June Heights, Mike Kendall, Advocate Vale. Thanks very much for your talk. I'm representing SABA, the business broker. As you know, many of our business brokers have been for years operating under the old Estate Agents Act in terms of it and holding fidelity fund certificates. And now, obviously, we're changing, and some will keep their FFCs and apply for the new one for business broking. Wanting to deregister on the estate agent side and re-register as business broking. The problem that we're having is in terms of it's the same company that we're running and the same trust accounts that they all have in their individual capacity. And now we're being asked when we're applying to deregister that company or deregister that trust account. Now that trust account is holding money in business transactions, sale of businesses that we've been doing for years. So we cannot deregister that. Is there someone, or can we have one person in the PPRO that all the business brokers can contact and put their applications through for applying to be registered as a business broker as opposed to a real estate agent?
Okay, your situation is akin to the one we discussed earlier. There was a similar question earlier as to somebody who wanted to deregister as an estate agent and open as a managing agent, and they had been operating and they wanted to use the same trust account. Now, the audit manager has confirmed with me that, and this is how we've been doing it, that all you need to do is your auditor has to wind up the estate agent portion of your business. If you were registered as an estate agent and if you had any estate agent operations. Alternatively, if there's nothing to do, he will then submit a winding up return stating that there was no estate agent business. And you will then get a new letter from your bank confirming that this is still the trust account held in terms of Section 54(1) of the Act, and that it is held by the business broker firm, and then you will use that to register. So if you want to get any details, you can speak to the audit department. You can either email audit@theppra.org.za, or alternatively, I'll give you the manager's email address. The audit manager is Thomas, THOMAS, .makupo, MAKUPO, @thepra.org.za. Now, Lady, maybe you can put Thomas's email up as well, please.
Yeah, please.
And you can do it through. It'll come through to us. But if you need to check up on anything and see if the audit department are happy, you can contact them with the documents, and they will send them through to us when they're satisfied.
Yeah. Okay. Thank you for that. Because yes, all of our chaps have been running just doing businesses. They haven't been selling real estate or estate agents. So when they phone up, they get all sorts of different answers, and that's why we're looking for someone that we can contact. We'll get the right information on that.
Yeah.
From SABA.
Unfortunately, it's the call center, and I prefer to remain mute on the question of the call center currently.
Okay, I have Nandi. Thank you, June. I have Nandi on the chat. Hi, Advocate. Please explain exemption regarding education and compliance of directors and principals, property practitioners. I'll come back to the hands.
Yeah.
Sorry, I'm not sure. The lady, would you just go through that again? I'm not sure what the question is. Explain what? Explain what?
They want to just find out the process of exemptions and complying as a property practitioner. for directors if they wanted to apply.
Okay, well, exemption is, I don't know if you're talking about a non-executive director exemption. Oh, gosh, I'm getting a feedback.
Okay, let me mute. There's someone speaking. Maybe Advocate Nandi, please raise your hand and let's clarify your question. I'm gonna go back to the hands. I'll come back to the chat because my system is taking long to load again the Q&A space. Let's go to Cynthia. Come back to the chat. Please unmute.
Hi, Naledi. How are you?
I'm fine.
Good. Naledi, I have two questions. First of all, we've sent all the necessary documents that were completed for our 2026 FFCs. And we are waiting now for further instructions from them in order to renew our FFCs. I think it was maybe invoices or something, not quite sure. I don't do the paperwork.
Okay, you want them to raise an invoice so that you can renew for your FFC. Your FFC is ending in December 2025.
Yes.
You want to renew for 26.
Correct. Yes.
Okay, send 7 Digital. Ask Vukani to raise an invoice to send you so you can make a payment, but your FFC will issue 1 January. I think, but they're busy. I'm just saying it in advance, but we will try to process. Advocate, do you want to add on that before I go to another hand?
Remember your payment was due before the end of October with or without an invoice. That is a legislation requirement.
Okay.
So if you haven't paid it yet, you're going to be accruing penalties.
Okay, so if we pay it, let's say right now, will we have it before January?
No, absolutely not. It takes 30 working days, and that's January. So that definitely you won't get it before January. But you would need to make payment immediately, and you would also need to have to find out how much the penalty is for November, and the first week of December.
Okay. All right. We actually did request this in time. It was before November, but yeah, I'll follow the guidelines you gave me.
Yeah, all the information is on our website. So we issued a notice, I think in July already, saying that our renewal season had opened, telling everybody to make sure that they make payment and submit the application before the end of October. So and in fact, our FFC invoices were issued already on the 1st of July. So you should have got yours then.
No, we didn't. This is the problem. We didn't get it. And secondly, we also got notice that payment has been extended to the end of November.
No, the notice that you got from us was that we are allowing people to continue to renew up until the end of November because of the fact that many of the FFC renewals property practitioners have failed to submit the application form with their payment.
Yeah.
And so both of those were to be required to be in by the end of October in terms of the legislation. So we said there would be a grace period up until the end of November. And if you paid and you submitted your compliant application before the end of November, you would not accrue penalties for November. But if you did not do it by the end of November, you would accrue penalties from the end of October, and the renewal then would be processed as soon as all of that was done. So that's the notice. It's on our website.
Okay. All right. And then furthermore, an FFC that keeps on being issued on the employer being incorrect. And we are now talking 4 years that we have continuously sent emails to please rectify it because we did deregister from that company and to change our FFCs. Now, this has not happened.
Okay, all right, then we need to look into that and see what the problem is. Maybe can you send your email to Naledi with your PIN number, and Naledi, maybe just send it to Lorato and copy me so that I can also have a look at what's happening there.
Okay. Would this be addressed to Naledi Mpaleli, registrations at registrations?
Naledi, I'll drop my email on the chat. Naledi, I'll drop it. Don't worry. I'll put it on the chat.
Thank you. Thank you, Advocate.
Okay.
Let me go to Luwen. When will we have portals for the trust accounts, etc., or for managing agent firms? The portal for managing agent?
I wish I knew. We are in the process of developing the system so that we have all of those profiles, which we don't have currently, and that's why we're doing it manually. So we're hoping that probably by end of February we will have them in place, and it's part of the development that is ongoing currently.
Yes, and I assume that I think they want to do them as and when we move. They will not load all the categories, 12 subsectors. So we'll start maybe with managing agents and auctioneers and so on. But I'm sure our IT will communicate on that one. Luwen, I'll just email our CIO so he's aware that there's a question like this and they can address it. Andra says, to clarify, does a managing agent still, okay, this one we've answered it. Sorry, advocate for that. Let me go to another one, Viv. Should an agent resign to go and work for another estate agency? Do we still deregister as agents if they want to change firms while they're holding a Fidelity Fund certificate to join another one? Do they deregister or move with that FFC, advocate?
If they go to another firm, if they register under the new firm within the 14 days, their current FFC will remain valid. And they will not get a new FFC, and they will not have to pay for a new FFC. So, because the current FFC doesn't have the name of the employer on it. So, as long as the firm deregisters them, and within 14 days, when they deregister themselves, or when they send us a notification, it's within the 14 days from the date that they left the other firm, and they say to us, here's the documents, please can you do an employment change for me? Then we will do that, and you will not get another FFC. Your current one, if it is valid, will continue to be valid until it expires.
And Yvonne, you are asking the same question as this one, so I won't read out your question because advocate just answered this one, so it will cover your question on deregistering if you are moving to another company. Let me go to Luzelle. If you are just a managing agent, do you still need to belong to FICA?
Yes.
Sorry, if you what? If you're a managing agent?
If you are a managing agent, do you still need to belong to FICA?
Yes, you do.
Okay, thank you. Let's go to Wilder. Please unmute, Wilder. Okay, let's go Nandi. Please unmute. Nandi?
Hello. Hi, advocate. Hi, Naledi.
Yes,
Can
please
you hear
ask.
me?
Yes.
Okay, thank you. Advocate, I missed on, I think it was on the 3. I'm trying to open my slides here. I had a volume problem there. I was so much interested on number 4, principal property practitioners and the director property practitioners. If you can explain there again.
I'm just looking, slide 4. My slide 4 is this one.
Yes.
Okay, so what this slide simply tells you is that if you're an estate agent and you want to register as a principal, you can only register as a principal estate agent if you register a business property practitioner as well. So you have to operate as a principal of a registered business property practitioner. So that means you register yourself as the principal of that firm and you register the firm as a business property practitioner. You have to be a director or a member or a trustee of that property practitioner if that property practitioner, that business property practitioner, is a juristic person. So if it's a company or a CC or a trust, the principal is required to be a director or the member or a trustee. The principal also has to have an NQF4, a PD4, an NQF5, and a PD5 qualification. Alternatively, you have to apply to Education Department for an equivalency exemption if you have a degree or something that is as good as that. And they will then give you an equivalency exemption if they are satisfied that you can get one. And then your CPD, you have to, as a principal, do your CPD. You have to make sure you comply with that and pay your necessary dues. And then on the other side, I've put duties of the principal, which are that you are responsible for the compliance of the business property practitioner that you're principal of. You are also responsible for the employees' professional conduct that work for you. And you're also responsible for the trust account and the trust money that your firm takes and holds. And then finally, we talked about deregistration, and I pointed out that principals must deregister the firm as soon as they cease trading as the firm. So that's that.
Okay, thank you. Let's go to another.
Okay,
Thank you, Advocate,
Thank you, ma'am.
for covering that. Nandi, we're going to share the slides with everyone who's in the meeting. Christelle,
Okay.
please unmute. Christelle? Okay, and Marie, please unmute.
Hi, I just want to know what happens to non-principal agents where the principal cannot register due to the system issues that you are experiencing at the moment with principals of multiple agencies. What happens to that agent that cannot renew their FFC because of that situation? Will they then also not be able to practice?
First of all, they can't, it's not a question of they can't register, they are registered with us. You mean they can't renew, they can't get their new FFC? Is that what you're asking?
Well, there's been a name change of a business. So what's happened is they've removed, it's a sole proprietorship, so they've removed the previous business trading as, but her new FFC under the company is not being issued. And we've been trying for 2 months now for that to be done. But
has the sole proprietor been deregistered?
Oh, no,
has the sole proprietorship been deregistered?
It looks like it. Because when you go on the sole proprietor's profile, it's only the other agency that she's registered under as a principal that's showing. So my FFC as a non-principal is not being renewed because of the system error. What happens to me on the 1st of January? Does that mean I cannot trade?
Okay, well, the system error should not be affecting a name change at all. All the system error at the moment is doing is where the principal has an FFC under another firm and therefore hasn't been issued with one under his firm, under this particular, the other employees cannot get their FFCs either. So in that instance, we are working on it and we're hoping that it will be resolved by early January. But certainly you are qualified, you are entitled to one, as long as all the payments have been made, as long as your principal has paid. In that instance, we will be happy to say that you were entitled to an FFC and you were entitled to operate on the basis of your status and everything else. And it was our fault that we couldn't issue you with an FFC.
Okay, so where do we request that letter from?
Okay, you will request that early in January. And you can request it from Vukani Mbata. His email address, I think, is in the chat.
Thank you very much.
Thank you. We have 10 minutes. Let me go take the
sorry, Naledi, it's Christelle. Yeah, I couldn't unmute quickly. Can I have a word?
Okay.
I just want to know, we've got a CC, and one of the members is staying abroad and is no longer active, but remains a member of the CC. Must we still renew the FFC every year, every 3 years?
Okay, the answer to that is yes, in terms of the Act. Every director you have
breaking.
I have to send the
sorry, am I breaking up? You not hearing me?
Yes, I can hear you now.
Can you see that thing of that command?
Okay.
Who's
Somebody
speaking
just
now?
mute, please.
Yeah, I'm trying to check who's that. Nandi, please mute. Let me mute them. Sorry, Advocate, continue.
All right, fine. So what I was explaining is that in terms of Section 4, there is an exemption application that you can make using the E1 form, which is in the regulations. And the regulation provides that if you have a non-executive director or a non-executive member, you are able to apply for an exemption for that director or member, on the basis that either he is a director or member who does not take play any role in the day-to-day activities of the company, or he doesn't oversee any property practitioner activities or perform any property practitioner activities. So you just get the E1 form from us or from our website or from the regulations. You will find it under Regulation 41, I think. No, beg your pardon, it's Regulation 2. Go under Regulation 2 and I think it's there. But you can also email us at Section 4 exemptions. It's section and then the number 4 and then exemptions at theppra.org.za. Please don't send it to exemptions at the PPRA, because that is not going to come to us and you're not going to get any assistance. That goes to education and it's for equivalency exemptions. So you just email them, be able to have to send in a resolution, CC resolution of the members with authorization that and confirming that he is in fact a non-executive director. And then we will be able to issue with an exemption for 3 years for him. And then if he's still a non-executive director after that time, you just simply apply on the same basis and we'll grant a further exemption.
Okay, thank you, Fiona. Fiona?
Yeah. Hi, Deborah. How are you?
Hi, I'm good. Thanks. And you?
I'm good. Thanks. Deborah, I just have 2 questions. At the time of renewal, we have a lot of agents who submitted a renewal plus a change of employment. So they paid the renewal fee plus they paid the admin fee of 640 to do the change of employment. However, the new FFC for 26 has been issued in the old firm name. Who do we address?
It would have been usually because the change of employment is done now, and if they're employed under the new firm now, they have to have an FFC for this year as well.
So what I'm saying is that they've got an FFC from 2023, which expires at the end of December 2025. They renewed at the end of October, like they were supposed to do. But in the interim, they had changed firms. So they had filled in the application form, the letter of appointment, the ID, the proof of payment. But the new FFC for next year has been issued in the old firm.
Okay, I'm with you. All right, so what we need to do is we just need to do a reissue of that. So if you will send a list of those, if you have more than one, to Lorato and copy me.
Okay.
And then I'll ask if it's actually not her job, but I think she's the best person to liaise with FFC renewals, and we'll get FFC renewals to reissue them.
Okay, thank you. Then my next question is, a lot of agents, I'm getting a lot of emails where they've renewed, but their personal home address has been put on the FFC and not the firm address.
Yeah, it will never be the firm address, because the FFC, as I've said, in terms of the regulation, the FFC operates for any firm that you operate under. So if you change and you do an employment change and this FFC is still valid for another 2 years.
Yeah.
If we put the firm address on there, then the FFC has to be withdrawn and you've got to pay for another FFC. And they'll be the first ones to complain that they've now been cheated out of 2 years of FFCs. So we cannot put that on. And the FFC template in the regulations requires us to put the geographical address of the property practitioner, and that is their personal address.
Okay, all right, that answers my question. Thanks a lot. Okay. Thank you.
Thank you for that. Advocate, maybe the few ones, the last one, I'll go back and take the last hand. Ferdi on the chart says, why has the PPRA revert to agents having to submit a printed and completed application form again, as opposed to an electronic application system?
Okay, first of all, there never ever was an electronic application system for you to be able to apply to renew an FFC. There was only an application form for you to apply to register. Now, the two have some differences, and we are in the process of doing an online electronic version of the renewal application, which you have to do. Now, the reason why we had it previously and it's down now is because the profile is under development, and we are in the process of doing a new profile that's going to have all sorts of other things that it can do. And previously, when you, under the old Act, when you renewed an FFC, all you had to do was pay. You didn't have to do anything else. The new regulations require us to get an application form for a renewal, as well as a registration, which is a pain in the neck for everybody, including us, specifically for us, but it's something we have to do. And that's why we are requiring you to submit that application form. And the actual renewal application form on the portal was never able to, well, that application form was never able to accommodate a renewal. So it wouldn't have worked. The system would not have provided you with the correct facility to renew. It would only have used that as an application to register. So that will be restored as soon as we have the new development done. And additionally, there will be an online electronic renewal form that you can fill in. But as I say, at the moment, we don't have that.
Okay, no, thank you so much. Colleagues, we only have 4 minutes. Let me take the last two hands, because, you know, usually when I do these webinars, I invite two speakers so that other speaker can breathe and drink water. So today, I really appreciate for Advocate to take all these questions alone for the past 2 hours. I can imagine it must be, you know, because she's been speaking. But let me take Valda, and then I'll take Mpulumeti, and so that we can close. Valda, please ask.
Can you hear me?
Yes.
Can you
Yes,
hear me?
Yes.
Okay. I thank you for this very informative session. We appreciate it. I closed my firm, my CC, in March 2024. I did a wind-up report, got a letter from the bank, closure of my trust account. I did all the things that was required to deregister. Then nothing happened. I keep emailing registrations at the ppra.org.za.
Sorry, just repeat. We lost you for a bit. Just repeat the last bit.
Okay. All right. I've been trying to deregister to no avail since October 2024. And every time when the PPRA reacts, they ask me to send a new letter of the bank stating the closure of my trust account. Now, I've done it twice, and the bank cannot keep reissuing a letter stating my trust account was closed in March 2024. So I really don't know where to go to anymore, because I sent everything that was requested to the PPR.
All right. Do you know who you sent it to?
To registrations.
Just to registrations.
ppra.org.za.
Can you send me an email, maybe via Naledi if you like, or otherwise to me directly? If you want to put my email address on, you can, Naledi.
That would be fantastic.
And just please mention, you know, that what's happened and the fact that you submitted everything. And there's absolutely no reason for you to keep getting new, you know, unfortunately, we have administrators who are not, who don't always apply their mind, and where you are giving certain documentation, it has to be less than 6 months old, and that's a legislated requirement. But something like that is definitely not required to be less than 6 months old, because whether it was issued now, or whether it was issued then, the facts are exactly the same. So that's fine. We won't require that. Let me just get hold of whoever's dealing with it and put a bomb under them and let them do the deregistration for you.
Okay. Can you give me your email address, please?
Yeah,
I'll put it
Naledi,
on the
do you want to write it on the chat? Okay.
Yes.
You just write it on the chat, then you can see it.
Mpulumeti, please unmute.
Hi, good afternoon, and thank you for taking the time to answer the questions. I just had a question on the deregistration aspect when it comes to managing agent category. If you don't have a trust account and you received an exemption, what else would you need to submit together with the request for deregistration? Because there wouldn't be an account to audit.
Okay. Now, if there's no account to audit and you have an exemption from that, then it will be on our system, and there should be no reason for you to submit anything like that. You would simply then, in your application and perhaps in your request to deregister, just simply confirm that you were given an exemption from the trust account. It will go to our audit department. They will see that the exemption is on their system, and and they won't require anything further.
Okay, thank you.
Right.
Thank you, Advocate. I have the last hand from Kristen. Should I take it before
Yes,
Lisa
sure.
can close? Kristen?
Sure.
Hi, thank you. I just want to make sure, Advocate, you answered me on my 3 questions previously, and I've just checked now on the PPRA website on my profile. My FFC for 2026 was issued for EXP Realty, where I'm a full status agent, and it shows my status as principal.
But how does your you mean the portal shows your status as principal? Yeah, because the FFC can't show your status.
No, I'm looking on the website, you know, where my status is recorded, and where all the issue where you download your FFCs.
All right. Well, it may be an error on the portal. As I said, they are working on the portal and they are doing an overhaul, so not everything's available. But if you wouldn't mind just sending us the PIN number for that firm and your PIN number, and just explaining that problem, and we'll have a look, and I'll get IT to have a check.
I will do so. Thank you, Advocate. Thank you.
Thanks a lot. Okay.
Okay, thank you. Liz Bear, over to you.
Thank you, Deborah. From NAMA's side, I just want to say, Deborah, thank you for your valuable contribution and the informative session in making the deregistration process more clear. Nalini, for assisting the administrative part of the webinar. Thank you so much, and may
it's my
all
pleasure.
have a well-deserved break over the holiday season and a blessed 2026.
Thanks, and to you too. Much appreciated.
Thank you for joining. Thank you, colleagues. Goodbye.